Thank you for joining us, everyone. Just going to give everybody a few minutes this morning to log on. We'll get started in just a moment. Good morning, and thank you for joining us. For this session, Summit is proud to partner with McAfee and Taft. Today, we will be discussing the latest trends and regulatory updates that could impact your benefit plan. We do have the Q&A feature available, so you can submit questions through that option. There may be time at the end of our session to have your questions addressed, but we will follow up with you after the session concludes if not. You can also submit any questions to us via email at marketing@yoursummit.com. I will display that email address again near the end of our session today. So let's get started. We have 3 guests joining us today. Our first is Brandon Long. Brandon is an experienced AV preeminent rated employment benefits attorney for McAfee and Taft. He represents regional and national clients with thousands of employees, including large publicly traded corporations and governmental entities. His achievements have earned him inclusion in the Chamber USA Guide to America's Leading Lawyers for Business, the Best Lawyers in America, and the Oklahoma Super Lawyers. Brandon serves as the leader of the firm's Employee Benefits and Executive Compensation Group. Our next panelist is Todd Rolland. Todd serves as the president of Summit's Employee Benefits Practice. Having been with the company since its founding, he has tackled the most unique and complex employee benefits situations. His experience is diverse and spans multiple industries. This perspective enables him to mitigate risk and guide clients to time-tested and creative solutions. Todd's professional designations include Certified Employee Benefits Specialist, Registered Employee Benefits Consultant, Retirement Plans Associate, and Group Benefits Associate. Our last panelist is Kaci Skidgel. Kaci is president of Retirement Plans for Summit. Kaci is the author of the book Path to the Summit: Strategies to Reach Your Company's Peak Retirement, and was acknowledged as one of the top women advisors by the National Association of Plan Advisors for 6 consecutive years. Most recently, Kaci was named by Financial Times as one of the top financial advisors, and the Summit team was named as a top DC advisor team in the country. And now I will pass it on to Todd to start today's session.
Thank you, Megan, and thank all of you out there for participating today. Brandon, we really appreciate you being a part of this. And first thought this morning, I opened up the paper and one of the first articles I saw was Zoom fatigue and how to best deal with it. So we hope all of you out there are doing fine within this new virtual world. And we're just thankful that you're here today. We've got a lot to talk about. There is a tremendous amount of activity going on within the health and welfare space. Some of this is still, ambiguous, if you will, and some of it is black and white and pretty much ironclad. But there's I think there's perhaps my perception is there's more confusion out there right now than there has been a long time. And I think there are a lot of influencers that are driving that, of course. If we have time at the end of the session, some of those of you out there that may be in attendance may be wondering the Blue Cross Blue Shield, big healthcare in St. Francis, what's going on, what is the latest in that? And I've spoken with leadership from those organizations in a certain sense, and so I'll give you my opinion if we have time. But let's jump right in. Again, Brandon, I appreciate you being here. It's always a pleasure to be with you. And we as a firm and many of our folks out there, I'm sure, have been receiving lots of questions that really relate to the American Rescue Plan. And there seems to be a lot of confusion regarding COBRA, the election of COBRA, the extension of COBRA, et cetera. So can you speak to that, Brandon?
Yeah, sure. And, our part of our problem here is that we have, kind of intersecting laws. We have the American Rescue Plan, which provides as a reminder for most of you, it provides free COBRA coverage from April 1 of this year through September 30th of this year for certain individuals who qualify. So we have the American Rescue Plan that provides this free COBRA coverage. And then we also have a different set of rules that are related that provide an extended time for people to elect and pay for COBRA coverage. And so we have, honestly, we got in February, we got this guidance that said, people have, you might recall, take you back to early 2020 when COVID first comes on the scene, and we get guidance from the Department of Labor that extends the deadline for individuals to elect COBRA and pay for COBRA until 60 days after the end of the announced national emergency. Well, that national emergency has not yet ended. And so this period is kind of was ongoing. Well, in February, just 3 months ago, the government comes out with this kind of crazy notice that says you have that extended period is now basically 1 year for every person. So, for example, if someone had a deadline of April of 2020 to elect COBRA under the normal timing rules, they have until basically April of this year to elect COBRA and to make payments, kind of a similar extended payment deadline. So they've given everybody, and think about everybody that was terminated or that had a COBRA event, after March of 2020, all through last year up until recently, they all have kind of their own 1 year extended period to elect COBRA retroactively if they want to, and pay for COBRA retroactively if they want to. And they're also extended deadlines. I don't want to digress away from COBRA, but you have that same 1 year extension also applies to like HIPAA special enrollment rights and the deadlines that would normally apply, like if someone had a new baby or a new marriage or something like that, and they wanted to add new coverage to the plan. They have an extended period, the same, everybody getting their own 1 year period. That rule applies to those events as well beyond COBRA. But let's focus on COBRA still for a second. So we have this guidance that comes out in February that says everybody gets their own 1 year deadline to elect COBRA coverage and pay for COBRA coverage. And then you add in the American Rescue Plan in middle of March that says COBRA is free for certain individuals from April 1 to September 30, and there are related notice obligations. And so we kind of have this scenario where employers are very confused because we have lots of rules and kind of intersecting consequences here. And I'd like to give you maybe some practical, if you'd let me, and I don't, Todd, interrupt me if you want me to mention anything specific that I am not, but I thought I might just give you some kind of practical guidance related to this issue if I can. So the American Rescue Plan, which is what you asked me about, provides this free COBRA coverage for certain individuals from April 1 through September 30. And to qualify, individuals, they had to have had a COBRA qualifying event that is a reduction in hours or an involuntary termination of employment. So if someone gets terminated or their hours are reduced, they would qualify or they would fit into that category. Some questions, that I have received this year or in the last few months are, well, what about gross misconduct? If someone is terminated for gross misconduct, would they still be eligible for this? And the answer to that is no, but the circumstances under which people where gross misconduct has occurred are very narrow. And so I would caution you, I kind of use the probably bad example. If someone commits murder at work, or if someone does something like steals from you at gunpoint at work, that's probably gross misconduct. If it's anything short of that, I'm skeptical. And there's lots of, I use kind of the extremity to kind of illustrate that the gross misconduct exception is very narrow. So basically, back to who qualifies. If you have a COBRA event that is a reduction in hours or involuntary termination, so if someone quits on their own and you didn't terminate them, then they would not qualify for this. So that's number one. Two, they elect COBRA coverage. Three, they're not eligible for Medicare. And four, they're not eligible for any other plan like a new employer's plan. If they meet all of those requirements, they get free COBRA coverage from April through September. The notice obligations, and if you wouldn't mind, for those of you that have a pen, you might just write down, I kind of have recommended basically 4 different notices go out to, and the government gave us some model notices, but I kind of practically speaking, I think employers should be sending out 4 different notices. One notice for that will go to anyone that had a COBRA event after March of 2020 that says, hey, you have the right, an extended period to elect COBRA and pay for COBRA, that 1 year extension that I mentioned, which is the guidance issued in February. So notice number one is sending a notice to people that had a COBRA event after March of 2020 that says, hey, you have an extended period to elect COBRA and to pay for COBRA coverage. The other notice I have that I have suggested that people send is a general notice to all participants in your health plan that notifies them of the 1 year extended period to make a, not just the 1 year extended period for COBRA events, but also for special enrollment. By the way, if you email me, and I'm not going to bill you or try to sell you some steak knives or anything, but if you want to email me, I have some samples or templates for these first two notices I can provide to you, and at no charge, of course. The third notice that you need to think about, so, one again is people that had a COBRA event after March of 2020, notifying them of the 1 year extension. Two is everybody in your health plan, notifying them of this 1 year extended period as it relates to not just COBRA, but special enrollment, HIPAA special enrollment, and other rules, because you may not know who those people are. That's why I suggest that second notice go to everyone. The third notice, and this is a government required notice related to the American Rescue Plan, is for someone terminated after April 1 of 2021. You've got to give them a notice of the free COBRA coverage that they're entitled to or may be entitled to. And the government has given us a model notice for that, which I also would be glad to send to you if you want me to. So just email me. And then the last notice would be, and you have a May 31 deadline for this, so we're not that far away. We're going to blink and it's going to be, June. But they gave us until May 31 to send people a notice who basically had a COBRA event from November of 2019 to present. And so these are people, this could be someone who was eligible for COBRA coverage back in November of 2019, and they didn't elect it, or perhaps they elected it and then they dropped the COBRA coverage. And the notice here, this fourth notice, is a notice telling them that, hey, you may have the right to free COBRA coverage. And the reason it goes back to November of 19, if you think about it, is for a lot of people that terminated involuntarily, or their COBRA event probably entitled them to up to 18 months of COBRA coverage. And that 18-month period would fall within this April 1 to September 30, at least part of it, period. And so they're entitled to free COBRA coverage as well, even if they never elected it way back when, even if they elected it and dropped it. But you've got to give them a notice by May 31 of this year that says, hey, you may have the right to free COBRA coverage, and kind of lets them know that. So there are four notices that people, I think, need to be sending out right now, Todd. It's notice overload. I mean, in my cranky opinion, people don't read half of these notices, but that's that doesn't change the fact that we, from a compliance standpoint, need to be thinking about this. One question also that comes to mind, people have asked me, is does the termination, again, for someone to get the free COBRA coverage, they had to have had either an involuntary termination or a reduction in hours. And the question I get asked a lot is, does it have to be COVID related? In other words, did we terminate people because of COVID, or what about people that were terminated because they were just a bad employee? They get it too. There's not any sort of a qualification that the termination has to be COBRA related.
Yeah. Yeah, that's good information, Brandon. I appreciate that. And from our perspective, one thing that is critically important for those of you out there who may be in attendance, if you are administering, or not administering, but you're overseeing a partial self-funded plan, including reinsurance, kind of be aware that most of the insurance companies, I'll say the BUCAs for lack of a different description, Blue Cross, United, Cigna, Aetna, and the others, they're recognizing the flexibility and the extension here, and they're covering that risk in the fully insured market, which is dictated by state insurance. But once you go into the partial self-funded world, you really need to be, your consultant needs to be in communication with the reinsurance. in place because these reinsurers are really pushing back in some areas. And I've seen, throughout the healthcare landscape, I'm seeing declination of certain claims, not necessarily just related to this, but there's just hypersensitivity to those areas contractually that they think they may or may not be liable for. So be sure that your consultant is communicating with you as it relates to verification and validation that the reinsurer is recognizing this and covering this. So I think that's something that's very important. Also, Brandon, we might move on here. Another big topic that's critically important to everybody on this call and on a national stage front for sure is mental health. And can you provide us some updates regarding what you're seeing, legalistically and legislatively over on the mental health side?
Sure. So you guys, this mental health issue, there's a requirement, a mental health parity requirement, and I bet probably all of you are familiar with it, but I'm just going to level set. It basically says if you provide coverage for mental health benefits in your health plan, the benefits provided related to mental health have to be in parity with the medical surgical benefits in your plan. And what you kind of think, well, what the heck does that mean? Well, basically, you can't impose more stringent financial requirements on mental health benefits than you do on medical surgical. And you also cannot impose non-quantitative limitations on mental health benefits in your plan, like pre-certification. You can't require pre-certification for mental health inpatient if you don't require pre-certification for medical surgical inpatient. So you can't just think of it as your benefits, generally speaking, the medical surgical benefits and the mental health benefits have to be equal. Think of it that way, just kind of for simplicity. And so two things that I want to mention to you, one relates to what I'm seeing in Department of Labor investigations that we've had in the last 24 months and very recently. And then the other relates to the year-end funding bill, which imposed new requirements on plans related to the non-quantitative piece. And I'm going to try to talk practically about these. So first of all, many of you, if I've worked with you, I might have talked to you about this, but we get in these Department of Labor investigations, and one of the questions that they ask at every single investigation going on right now, and they call an audit an investigation. So when I say investigation, just think of it as an audit, kind of a random audit. One question they've asked every single time is provide documentation that demonstrates your efforts to comply with mental health parity rules. And there's kind of this Wizard of Oz math that has to be done for a lot of plans on the financial components like copays and deductibles. There's math that has to be done to make sure that you pass these math tests on the quantitative, the financial pieces. And then on the non-quantitative side, again, it's kind of, you can't impose things like pre-cert on mental health that you don't impose on medical surgical. So you have the financial component, and then you have the non-quantitative component. So you get this question from the Department of Labor that says, please tell us your efforts to comply with mental health. And what happens is the employer, and I'm not talking about my good friend Todd. So, but in a lot of these that I've had, especially in other states, what happens, the employer asks their consultant and says, hey, what do we have to show that we've complied with mental health? And the consultant will say, well, that's not my deal. It's kind of like the Dumb and Dumber deal. I don't know if you saw the movie Dumb and Dumber where the bird gets killed and, Jim Carrey's like, it wasn't me, it was this guy. That's what happened. Your consultant will say, well, it's my network provider or the TPA. And then the network provider or the TPA will say, it's not me, it's him. And so it's kind of this, the employer's sitting there like, well, who in the heck is doing this? And the answer is it has not been done as an industry. It's just kind of a miss, generally speaking, that has not been handled or thought about. And so then what we end up having to do is we have to hire an actuary to take claims data historically, like 5 years ago, and run mental health parity testing, again, because there's math on the financial piece that has to be run to demonstrate that you pass these tests. And that is expensive. It's like 10 grand a year to go hire an actuary to do this retroactively. And if you've changed network providers, it really sucks because your old network provider is probably not very motivated to help you getting your claims data. And so my practical takeaway on mental health is to ask your consultant, and it may ultimately fall to your network, probably does fall to your network provider, but ask your consultant or somebody to give you something for your file every year that says your plan passes mental health parity, so that later, when, just like if you've got a 401k plan that you run, you'll get a non-discrimination testing report every year from your record keeper that says you've passed coverage or the average deferral percentage test or all those other crazy tests we have to pass on the retirement side. You get something from your record keeper every year that tells you passed. Well, just ask for somebody to provide something similar to you on the health side. You may have to pay some extra money. It may cost you a little bit of money extra if they need to hire someone like an actuary or something to run that. And it probably won't be 10 grand if you're doing it in real time, but just something that you can put in your file so that you're not having to scramble around later. And then secondly, the year-end funding bill, and I say year-end December of 2020, one of the things it required, or one of the requirements it imposed on health plans that was effective February 10th of this year, just a few months ago, so it's in effect now, is that it says health plans that impose non-quantitative treatment limitations. And again, a non-quantitative treatment limitation is not the financial piece. It is like a pre-cert or some sort of other hoops that people have to jump through to get mental health coverage, step therapy, medical necessity review, those prior authorization. Again, if you have any of those, if you don't really have to worry about this. But if you do, if you have any of those in your plan, you've got to perform that analysis every year. And then you've got to be prepared to document and produce that information to the government, the Secretary of Labor, Secretary of Health and Human Services, and the Secretary of Treasury if they ask for it. And we know that they've started asking for it. And so, again, this is something that I would harass your consultant to kind of help you with.
Yeah. Thank you, Brandon. And along those lines, with the latest recent announcement from HHS regarding sexual orientation and enforcement protection and how that relates to whether plans should provide coverage or not for that area, can you speak to that real briefly as well?
Yeah. So you guys, if you are a federal contractor, and that's broader than there are a lot of people that are federal contractors that you wouldn't think are federal contractors, because a lot of people have contracts with the federal government for various things. There was, in a nutshell, we have went through basically 3 different versions of the rule I'm about to mention to you because of 3 different presidents with 3 different political thoughts on this. And so you go back to President Obama, we have this rule that says if you're a federal contractor, you cannot discriminate against people based on their sexual orientation as it relates to the provision of several things, including benefits. And so you kind of think, well, what the heck does that mean? What does it mean to say that you can't discriminate against someone based on their sexual orientation as it relates to benefits? Well, I think an example of this might be if you had a provision in your health plan that says we do not cover treatment for gender dysphoria, or we don't cover, sex change procedures. Those kinds of provisions are things that you need to revisit, because under Trump, that rule kind of went away. They pulled it back for federal contractors. And then recently, and I say recently, like within the last 5 days, I think President Biden has kind of went back to the old President Obama approach. And so I think if you're a federal contractor, you definitely you need to reevaluate how your plan covers or doesn't cover treatment for things like gender dysphoria. Beyond that, if you're not a federal contractor, you might recall there was a Supreme Court, a U.S. Supreme Court lawsuit last year, or decision last year, called Bostock. I think it's spelled Bostock if you wanted to Google it. but it basically said that Title VII protects people based on their sexual orientation. And it wasn't really a benefits decision, but Title VII also applies to or can apply to benefits. And so for those of you that are not federal contractors, even though President Biden just issued this rule, and I was encouraging people that are federal contractors to evaluate their plan provisions because of that, which is true, even for non-federal contractors and really for everyone, because of the Bostic decision, we probably should be talking about and thinking about this anyway. Because what has not happened, to my knowledge, we do not yet have a lawsuit, a court decision where an employer has been sued, and the argument being, hey, I requested treatment under my employer's health plan for gender dysphoria. They would not provide it. They have an exclusion in their plan for that, and that discriminates against me based on my sexual orientation. That Bostic decision from the U.S. Supreme Court creates significant risk for many of you on this issue. And so somebody will get popped for this, Todd. At some point, somebody will get sued. And then the employee, and I can just again, working for a lot of different employers in this region, I think it's not common for plans to cover treatment for gender dysphoria, even post Bostic. People are still kind of waiting on the sidelines saying, I'm not going to provide coverage for these kinds of treatments. And I'm going to wait, but somebody will get popped, and it's like you probably at least should give some thought to that, Todd, before it's you, or and because you don't want to be the one that everyone says, well, that's the XYZ company lawsuit that says we have to do that. You don't want to be the XYZ company, and somebody will be that at some point.
Yeah. Appreciate those comments. It's very applicable, Brandon. Let's switch gears. Let's just a little bit. I know that your firm, you were heavily involved in the pharmaceutical area. Senate Bill 821. The president vetoed that recently. I just read in the Journal Record yesterday, that the fight is not over. There was another article. I know that our firm, on behalf of our clients, were also involved in the game, if you will, because we did not see favorably as it relates to this regulation. And as it was applicable to our clients being able to control costs. A lot of elements to this that we weren't in favor of, but can you speak to that? Because Brandon, for all of those out there, I mean, he led a pretty hefty initiative in opposition to this with several large employers and other influencers throughout the state. So if you can speak to that briefly, Brandon, that'd be great.
Sure. So, this issue about we're talking about an Oklahoma state law that there's already a law that was passed in 2019, the Patients' Right to Pharmacy Choice Act, that is designed to help independent pharmacists, which nobody hasn't. I mean, I say nobody, the employers, and I bet many of you probably love your independent pharmacists, and many of you probably need them for your plans, and they provide tremendously valuable service to their communities, and they're, often very good people, and their business model is at risk because of, the changing, just like the hardware stores are getting replaced by the Lowe's and Home Depot, and same thing with small town retailers and Walmart, and that same kind of phenomenon has happened with independent pharmacists. Well, so the legislature has tried, and Senate Bill 821 would further expand protections for independent pharmacists. They have tried to kind of protect their business model through these various state laws. And it's really admirable, and I understand, again, what they're trying to do. But they view this as, the legislators view this, and the independent pharmacists, they complain about pharmacy benefit managers, the PBMs, which think of them as the third-party administrator for your pharmacy piece of your plan. They,
Right.
The independent pharmacists hate PBMs. And so they view this as an issue between independent pharmacists and PBMs. And so when they pass these laws, they think they're targeting these evil PBMs, evil in their words, but really you guys and me, we are,
Yep.
as employers, we are the payers. And so, unfortunately, what this law would do is, number one, I mean, and there's a lot to it, but I'm going to just give you kind of two very quick points. One, it would define pharmacy benefit management so broadly that it would include things like billing and processing of claims. And so for a lot of you, you could yourself, for your own health plan, be deemed to be a pharmacy benefit manager under that definition, which makes you think, well, do I need to get a license from the insurance commissioner to act as a PBM like CVS does for my own plan? So that's kind of ridiculous. And then secondly,
Yep.
there's a provision in the law that prohibits steerage. And so what it says is, and it's very tricky because this is targeting PBMs, but the PBMs, it's telling PBMs, you cannot allow financial incentives for employees to utilize one pharmacy over another. So a lot of you, for example, you might have historically had mail order where people can get certain specialty drugs that are very expensive. They get them
Yep.
from one source under your plan at a reduced cost. Well, under this law, you'd be prohibited from steering employees from one pharmacy to the other. Well, where we are is the governor vetoed the bill. The governor listened to, and I really admire, and can't say enough positive things about the governor and his staff and just their kind of business and how smart I think they are. And maybe that's because they ultimately vetoed it and agreed with, but I just appreciate so much the perspective. But now the fight is kind of back to the Senate, where we're trying to get the Senate to sustain the veto because they can override a veto if they have enough votes. And so that's where we are, Todd, is we're working, and I've got meetings set up in the next few days where we've had, I think, 6 of them last week, and other employers are out there also meeting with them, trying to get the senators to understand that, hey, this is not about PBMs and independent pharmacists. You are trying to interfere with employer plans. You may not think about it that way, but that's effectively what you're doing. If you're telling my PBM that we can't steer employees to one pharmacy that maybe is a great utilizer of generic drugs, or maybe they provide great round-the-clock service for certain specialty drugs that, frankly, our independent pharmacists can't provide, then you're interfering with employer plan design, and that's not good for anyone. And so I'll kind of stop and say, Todd, on this topic, really, it's, in my mind, no different than what has happened on the medical side, which is, I think a lot of employers have achieved tremendous outcomes for their employees by getting the employer and the provider to kind of work together and really, in a lot of ways, eliminate or minimize the presence of the middleman through direct contracting and bundles, things that you guys have been innovative on for a long time. So that kind of discussion needs to be happening on the independent, with pharmacists too, with employers and pharmacists, finding ways to help them rather than handcuffing employers and restricting us and kind of providing a one-size-fits-all so that we can protect one industry. Because, again, what's next? Is it durable medical equipment? Is it radiology?
Right.
What about small-town lawyers? I mean, everybody feels sorry for lawyers. I'm being sarcastic, obviously, but what about the small-town lawyer that says, hey, I'm getting screwed over because the big law firms they're putting me out of business. And so are we going to pass laws to protect their businesses? And that's really kind of what that is about, Todd.
Yeah. Well, I think it's important for those of you out there, employers, if you're not familiar with Senate Bill 821 and what has transpired there, you might get with your consultant and ask them about it. We've been very involved in this because we've done some projections, and the net impact we feel like in terms of inflationary trajectory or just higher prescription costs is very meaningful to our clients. So from that perspective, we've been involved, and we've been opposed for a variety of reasons. Like Brandon said, there are some good aspects to all of this, but understanding the language and the domino effect is critically important when we're dealing with an issue like this. Well, we've got a variety of other topical areas, radical new transparency rules, surprise billing, DOL investigations that are spiking, consultants' disclosure of compensation and how they're paid. But Brandon, just here in closing, and then we're gonna move over to the retirement plan side here shortly. But this surprise billing, the regulations revolving around surprise billing is getting a lot of attention, particularly as employers are taking on everything from self-administering a plan to direct contracts, et cetera, et cetera. So can you speak to that for our audience just for a moment?
Yeah, there are new rules that go into effect in 2022. This all ties back to that December of 2020 year-end funding bill. And part of the year-end funding bill included something called the No Surprises Act, which created these new surprise billing rules that apply for plan years beginning on or after January 1 of 2022. And so this will impose pretty significant requirements on plans related to scenarios that are, the most common scenario you'll hear people talk about on this topic is this, where someone looks at their plan and they find an in-network provider and they go to an in-network provider for a surgery of some kind, and then they receive an out-of-network bill from an anesthesiologist. That's a very common scenario.
Right. Very common.
And the rules are they hate that. I mean, the regulators hate that. People hate that. I've dealt with that here on our plan. People get very angry because they've really tried to figure out and go to the right providers to minimize their out-of-pocket costs. And then they get these nutty bills. And so these rules are going to generally prohibit that. And also there's similar rules, surprise billing rules, that will apply in the ER context and the air ambulance context. And so there's a lot to that. If you want, you guys, and again, this is not a Trojan horse for me to sell you anything or try to send you a bill for legal services, but if I have a blog, ERISA link, ERISA.com, and I posted an article on January 4 of 2021 that covers the surprise billing rules and other things. And if you wanted to look back there, you can kind of see more details about it. But just know, I would ask your consultant to kind of help you. And I suspect your network provider and TPA is all over this for you. But we're only 6 months away from 2022, 7 months or so, and so it'll be here before we know it. You might just ask them what you need to be thinking about, if anything, as it relates to that, because it'll be here before we know it.
Yeah. Thank you, Brandon. Those are good comments. I might make a couple of closing comments from my perspective. One is there's so much out there. We could cover much more. We may, in short order, put together an additional webinar with Brandon to cover some additional areas. I would like to mention just a couple of areas in closing here. This idea within healthcare of price. We are all of us, most of us on this webinar are buyers of healthcare, and then we have sellers of healthcare, and then we have intermediaries in between. But the buyer certainly wants to know what we're paying when we're buying from a seller. And we have transparency rules in place now. Big healthcare, certainly big tertiary care facilities, the big hospitals are required to disclose their pricing per se. The key there is you have to define what pricing means. And so it takes somewhat of a PhD to be able to go out and pull the data at a federal level to determine what pricing is. But I do think that disclosure of pricing to better position us as buyers of healthcare is really going to become more prevalent in the future. We as a firm are extraordinarily excited about that because that positions all of us for a better experience. And price is important. Quality of care, no doubt, is critical, but price matters. And so I think we're going to see the renditions of the current requirements enhanced in the future. I hope. I know Brandon would say that's going to be a hotbed because the lobbyists are big and strong. The state of Oklahoma in the Journal Record I just saw yesterday is entitled "Oklahoma Passes Transparency in Healthcare Prices Act," led by Carol Bush, but it was House Bill 1006, new out. I won't go into it in great detail because it talks about cash price here. And there's a big difference when I'm at a provider paying cash versus filing a claim third party through an insurance contract. So the pricing can be a lot different, but I'm excited about just all the activity in that area because price is important. Quality is critical, but price is important. So I wanted to mention that as well. And at this time, Brandon, I want to apologize to you because there were other areas I think we were going to try to go over and we don't have time. But at this time, I'd like to turn the program over to Kaci Skidgel. Many of you out there know Kaci. She's awesome. She's highly credentialed. She's extremely passionate about retirement plans and has received great recognition as a result of that. So I'm going to let Brandon and Kaci cover a few areas, and we'll just close by saying I appreciate everybody today for sure, and I hope this was helpful and meaningful to you.
Todd, and thank you, Brandon, as well, just for the time today. I really didn't know that we were going to get to talk about Dumb and Dumber today. I didn't realize that was going to be a part of this. So I got very excited when you started going down the Dumb and Dumber. We're definitely my family fans of Jim Carrey and Dumb and Dumber. So, but it's interesting to me that Todd brought up the transparency in healthcare, because you and I have been talking about that for how many years with respect to retirement plans. So as I start to listen and hear what's going on in the healthcare side, I feel like we're kind of 8 years ahead of that, where we've so we dealt with that in the early 2010 time period, and so that was just an interesting to start to hear that percolate, and I can only imagine what they're about to deal with, all of the consultants. So
in the litigation too, think about that, Kaci, all the lawsuits that we've had on the retirement side about fee and cost transparency and expenses, and understanding every expense and every way everybody gets paid. That has not happened on the health side. And so in addition to the compliance stuff, think about the litigation that has been going on the retirement side to kind of flesh those out. And the health side hadn't even gotten started. It kind of scares me a little bit. So.
Yeah, I'm thankful you just said that, and then I'm sad for all of the healthcare consultants that are about to have to go through that, because it's just a constant at this point for us. So someone will make some good money on that. Yeah. But from our perspective, Brandon, I feel like 2020 seems like a lifetime ago, because there was so much. We had talked about secure, and then all of a sudden kind of carpet got taken out from underneath us because of the COVID and CARES Act. So really, I did want to just talk about, if you don't mind, updating about the QBAD. And I know us as a consultant, we've talked about it with some of our clients, and I don't know who came up with QBAD as the acronym, but sounds like a poor choice of words. But then again, it's about birth and adoption, which I think should be exciting. So I don't know how who decides these things, but would you, Brandon, if you don't mind, explain what it is, and also, why do our employers need to consider adopting the provision? We're going through restatements right now. What should they be aware of?
Yeah. So in December of 2019, so I was talking about the government funding bill in December of 2020 with Todd, and I'll take you back 1 year before that, December of 2019, before COVID, before any of us knew what that was. In that year's year-end funding bill was the Secure Act, and part of the Secure Act included a provision that allows plans to add a distribution feature for participants who've had a new baby or they've adopted a child. And so generally speaking, it's a new distribution feature that allows, if an employer decides to turn it on, it allows participants who have a new baby or adopt a child to take a distribution of up to $5,000 from their retirement account. It's got pretty cool tax benefits, because there's normally, if you're under 59 and a half and you take a distribution from a retirement plan, you'll pay a 10% excise tax. There is no 10% excise tax that applies to these birth and adoption distributions. And another cool feature about it is that you can recontribute it to the plan later. And so you can put the money back into the plan, which is almost never heard of except for in the loan context, or maybe our COVID distributions that we talked about forever last year. So that's kind of at a high level, $5,000, pretty cool tax benefits, and you can put the money back into the plan. Well, that technically people could have turned that feature on in January of 2020, but almost no one did, because we were waiting on guidance. And we got guidance in September of 2020 from the IRS that kind of clarified a lot of things relative to these birth and adoption distributions. And so September of 2020, I know that was a while ago, but it relatively speaking was not that long ago. And the record keepers, the Fidelities and Vanguards and Empowers and Prudential and Milliman, they weren't really ready to turn that feature on. Either they certainly weren't ready in January of 2020, when technically it could have been allowed, and then they were not ready in September of 2020 when this guidance came out, and some of them are still not ready now. And so I think just recently, the reason we're talking about this, Kaci, and it's coming up, is because just recently the record keeping community is starting to kind of send notices to their clients saying, hey, remember those birth and adoption distributions? We're ready if you want to turn that feature on. And so, and again, I think, like we're with here at the firm, we use Fidelity. And I haven't received such a notice from Fidelity. I don't think Fidelity is ready to administer them. So still, there are big players in the record keeping space, Kaci, that are not ready to turn this feature on, not yet. And so I think it will be something that is very common. I personally think, I get asked a lot, should we turn this feature on? I think everybody is always worried about ensuring their participants are not, self-destructing, making dumb decisions, taking money out before they should. But it's only $5,000. A lot of these, like I know just from a lot of our folks here, a lot of the, even lawyers and paralegals and stuff that have new babies. I mean, there's a financial cost, as we all know, to having kids. And so it's a nice feature. It's low risk for the employer because the employee gets to self-certify that they qualify. One thing that I get asked there, Kaci, just practically, and then I'll pause, about birth and adoption distributions is what obligation do we have to make sure that people qualify for these? And the answer is that the rules say they can self-certify. And so you're not really required to go in and double check that they've had a baby or they've adopted a child and otherwise meet the requirements. They can do that themselves. But if you have actual knowledge that they didn't qualify, then you have to take action. And so what has happened recently, like even just this morning, I got an email from a client and their record keeper had given them the heads up that, hey, we see that you've had, Brandon Long has had 3 birth and adoption distributions since we turned that feature on back in March or whatever. And you're like, well, unless Brandon and his wife have had 3 babies or adopted 3 children, he probably didn't qualify. And so then what do you do? Well, the answer is at that point, if you learn that somebody has taken these distributions and they didn't qualify, you probably have an obligation to go to them and say, hey, it looks like you've taken some birth and adoption distributions and you may not have qualified for all of them. Help us understand what we're missing here. And then if they don't, you probably need to, or didn't qualify, you probably need to have them put that money back into the plan because they weren't eligible for those distributions. But short of something coming to your attention, I normally do not advocate, Kaci, for people kind of sticking their head in the sand, but I do not think, especially for those of you that have a lot of employees, that you want to get into the business of looking at everybody's birth and adoption distribution forms and making sure they qualify. I would let your record keeper handle it. If something comes to your attention, you can deal with it. But otherwise, I actually think it's a great feature. Once it's available to our plan here, once Fidelity makes it available, I'll turn it on for our employees because I think it's a pretty low risk thing. And it's nice. I was adopted, and so I kind of have a soft spot, I guess, for people that need some expenses covered, and I think it's a good thing. And it's not much money, and they can put it back in if they later can afford to.
Yeah, and I agree with that. I think going through restatements now is kind of the perfect timing for all of these things that are coming up anyway. And I definitely am of the camp as if people ask, should we do it? I don't see the negative. I guess just you talking about the self-certification would be probably the only place that an employer might, have a little bit of pause if they know otherwise. But well, thanks for that update on Secure. So kind of then switching gears to something that I feel like is just now a part of our reality especially with remote workers. Cybersecurity is more and more common, and the dark web and all of those things that come with it. I've seen quite a bit actually of litigation and some horror stories that you and I are seeing with respect to employees who have had accounts just completely wiped out. So a few weeks ago, I know that the DOL had unveiled their best practices with respect to cyber and hiring the service providers. And what I had seen, Brandon, was that it was on the heels of the Government Accountability Office having produced a report and saying, hey, DOL, we haven't seen anything from you about mitigating the risk. So interestingly enough, DOL then gets involved and says, yes, since there's, I think it's about $9.3 trillion at this point in retirement plans. So will you give us kind of an update, Brandon, on what the DOL guidance has said at a high level with respect to this? I know there's a lot coming out.
Yeah, sure. So mid-April, the Department of Labor issues guidance on this topic. And the kind of in a nutshell, it says we need to ensure as part of our fiduciary duty to our plan that our vendors have strong cybersecurity practices and that you understand them. And so that part of your decision-making and hiring them and evaluating them on an ongoing basis ties into how strong they are with their cybersecurity protocols. Here's what I would say at a practical level. Actually, I want to tell you just very quickly about a case, and then I want to give you a practical suggestion. So there was a case very recently involving Abbott Laboratories, which is the group that started the student loan matching stuff that a lot of you probably might recognize that name from that. But they had a scenario where with their plan where an individual's account got hacked and that individual lost like $400,000 because an imposter was able to kind of work around the cyber protocols of the plan administrator, add a bank account, and then request a distribution. And so this participant, this 401k participant lost, like 400 grand. And when that participant's account was not made whole, the participant sued everyone, including the employer, which frankly, I probably would have done too. Because you think about like your bank account. If I had $1,000 stolen from my bank account today while we're doing this, I would expect my bank to make my bank account whole. And I think plans have the same. I think people in plans think the same about their record keeper and or their employer. Well, here's the reason I mentioned that, and going back to the Department of Labor guidance. One of the components of the Department of Labor guidance, it says when you contract with a service provider, make sure the contract requires ongoing compliance with cybersecurity and information security standards, and beware of contract provisions that limit the provider's responsibility for security breaches. Why I mention that is when you ask your record keeper, your Fidelities or Vanguards or Empowers, or we could, Prudential or whoever, Principal, Milliman. I feel like there's so many of them. I don't want to leave anyone out, but I'm just randomly going over them. When you hire them, or when you ask them about their cybersecurity, you might say, it might be as simple as having a conversation at your next committee meeting and said, hey, I listen to this short, bald lawyer talk about cybersecurity and guidance. Tell me what you guys are doing to comply with that. And that's something I would encourage you to ask them about. They will go to great lengths to tell you how awesome they are to protect data and all the Campbell soup, Wizard of Oz stuff that goes on behind the scenes to make sure people's accounts are protected. And that's all great. But here's what I want to know, and here's what I think you should want to know. What if none of that works? What if, like that Abbott Laboratories case, what if a bad actor, because bad actors that are motivated and smart can often find ways around, just like they did in that Abbott Laboratories case. What if a bad actor hacks my participant accounts? What's your policy on making them whole? Don't let them, bog you down with all they're telling you about how great they are to protect data. And that you need to know that. But ask them and press them to understand their written policies related to making people's accounts whole if the wheels fall off the wagon. And you will find with some of them, you guys, that some of them require, in order they have a guarantee of some kind. Some of them have a guarantee of some kind that will require, as part of that guarantee, that says, hey, if someone's account's hacked, we will make it whole if, and it's the if part that you need to know, and that is if the participant has turned on I'm making this up, two-factor authentication, or if the participant has done A, B, and C, or if the participant did not do X, Y, and Z. And so I think we need to know what those ifs are. In other words, what do they kind of make what strings do they associate with their guarantee? Because if your participants don't know what those, if you don't know what they are, your participants probably don't know what they are either. And to the extent you're able to get information that says, hey, if an account is hacked, we will make it whole if the participant has done A, B, and C. I think we need to tell our participants that. I think we need to let them know that, hey, send them a notice that says, hey, to everyone that says, hey, if you want your account to be fully protected, you need to do A, B, and C. And that will give you the full protection of your record keeper's, guarantee or whatever. But again, if we don't tell people that, if we don't even know what it is, they're not going to know what it is. And so we need to find that out. And again, when you ask about it, they will immediately, because it's like it's like a hitting a button, and then you've got this head that just starts talking to you. They start telling you about their cybersecurity protocols. And I'm like, that's great. That's not what I'm asking you. What if none of that works? When will you make our participants whole, and what strings are associated with that? Because I want to be able to tell our employees and participants about that.
That's a great point, Brandon. And I think, what you started with is where I'll kind of just finish with is it is that fiduciary obligation, right? So you, the employer, your job is to do what is in the best interest of your plan participants. So this is just you getting knowledgeable and making sure. That's one of the places that you always talk about is, are you monitoring your service providers? So this is a part of your monitoring, is what I'm hearing from you. This is a part of your monitoring your service providers and making sure that they are then acting in the best interests of the participants and their beneficiaries.
Absolutely. Yeah.
I appreciate that. And I know we're running low on time, and we actually had some other things too, to Todd's point, that we were going to try to hit on, because I could have asked some other questions about this. I would say if anyone that's on the call today would like the tips for hiring a service provider that the DOL has produced, the best practices that were recently published, there's 3 or 4 different things that they actually have out. I'm happy to send that. If you'll just shoot me an email, would love to do that for people. I didn't know, Brandon, maybe what we'll do for the missing participants, Brandon and I had talked about that one as well. And I don't know if you got anything quick, or if we should just go ahead and say maybe on the next one, we can address some missing participants. What do you think, Brandon?
Yeah, I think I just gave like an hour-long presentation last week to a CPA group on missing participants. So that I would be happy to cover that in some future discussion. I actually would like to, it's like enough about me, but let me talk about me one more time. Maybe an ask of you guys. So we talked about on Todd's, on the health and welfare side, that the state law initiatives. It is really important for our employers to get involved and be aware of the initiatives going on at the state level. And so, we created I think Summit's a member of it, a coalition in the Oklahoma Employers Healthcare Alliance. There's no hidden agenda here other than employers getting together and sharing ideas and learning from each other. It's not a disguised sales thing or legal billing or whatever. But these state law initiatives, the reason that we were able to get the governor's attention and certain legislators' attention is because they really care about hearing from employers, but they often don't. And so that's really what we're trying to do. And I would love for you, if you're interested and not a member, to email me. And we're not, there's normally all these coalitions have some sort of a small fee every year to be a part of it. But for 2021, the coalition's waiving that. And we just need more people so that in the off legislative cycle, we can kind of start getting smarter about some of these, how we're going to communicate with our legislators about how these laws have a real impact on us and our plans and our costs. So that's it.
Perfect. So if anyone is interested in that, again, we know we ran out of time today. We sure do appreciate Brandon's insights and knowledge and just the wisdom. And obviously, we're thankful for the partnership that we have with McAfee and the ability to do this for our clients. But if you all didn't get a question answered, please just reach out to marketing@yoursummit.com. I think, Megan, I'm going to pass it back to you for the close. And we just want to say thank you to everyone.